An update now on a case, a story that we've been following for a while now, surrounding an FWC employee who was fired just a few days after sharing a social media post in the aftermath of the death of Charlie Kirk. So this happened back in September. When we first started tracking this story, Brittany Brown worked as a biologist for FWC and shared a social media post that FWC said made light of Kirk's death. So she was fired. There was a lawsuit filed against the FWC over that termination. And yesterday in Tallahassee, big hearing in federal court. I want to bring in Gary Ettinger, who is an attorney representing Brittany Brown in this lawsuit. He's a well-known First Amendment attorney out of the Gainesville area, and disclosure, also the father of one of our great reporters here at Fox 35, Marie Ettinger. So, Gary, good talking with you. We appreciate you joining us this afternoon here on Florida Live.
Thanks for having me.
So, Gary, first, this big hearing yesterday in this case, I know seeking an injunction that would require the state to reinstate Brittany Brown in this case. The state says essentially that they got hundreds of complaints about this social media post, and that had they not fired her, it would have continued to disrupt operations and erode public trust of the FWC. What was your argument against that in court yesterday?
A nutshell, a couple things. One is you have to consider who Brittany Brown is. She's a state biologist. She's not head of an agency. She doesn't make policy. She doesn't really have a forward-facing role. She's a biologist. And so the idea that that's going to bring the agency into disrepute for what she does on her own time, a private social media post, that just doesn't carry any water. In terms of the backlash, if you will, there's no evidence other than a statement that says we received 100 media calls or 100 citizen complaints. So if that happened, you'd expect FWC to come forward and submit those into evidence to show this, public outcry that's somehow going to interfere with the mission of the agency. And that didn't happen. Also, we're in a social media connected world. And for citizens to respond to a viral post, in this case by a group called Libs of TikTok, who don't like posts like this Charlie Kirk meme, to say that 100 people contacted the agency is nothing. That just is a click of a button these days. The crucial legal question is whether the post actually interfered with the agency's operations. And the evidence in this case shows that's not true, that the people who Ms. Brown actually works with, her colleagues at FWC, are rather supportive of her. She's in the running for an award they call the Purveyor of Awesomeness. So the evidence is exactly the opposite of what the state would have to show for, some sort of discord that shuts down the operations of the office. So when we're balancing First Amendment versus the needs of government can't just say, oh, we were inconvenienced. That does not outweigh the vital First Amendment interests of citizens in this country.
What's most concerning to you about this case?
A couple of things. One actually is the close relationship apparently between this social media site Libs of TikTok and the administration. So what we see here is the Libs of TikTok website actually published a statement saying that Britt Brown had been fired by FWC before that was even publicly announced. So, that close interaction between a right-wing media site and government is kind of disconcerting. No one should have that level of influence. And the other thing that's troublesome is, we're citizens in an American democracy. We're supposed to be able to speak our minds without fear of being punished. And so cancel culture is a thing, but that's just private citizens doing private citizen stuff. When government is involved, we cannot tolerate that kind of censorship. And particularly over something as inoffensive as Ms. Brown's post. She's not advocating for violence. She's not saying we should overthrow the administration and kick all the Charlie Kirks in America out. She's just making a statement that, America is going to move on, that the death of Charlie Kirk was not a personal tragedy for her. And it also includes a political statement objecting to one of the more outrageous things that Mr. Kirk said during his life. Citizens are supposed to be able to say that without fear of losing their job. That's why we're in court.
But does the First Amendment shield employees from the consequences of the speech they make, even if the speech itself is protected?
A qualified yes. So when government is the employer, citizens have fewer First Amendment rights, or they're more limited rights than if it was just you or I posting on our own Facebook. So I'm employed in the private sector, right? I'm my own boss. But when government's involved, government also has to control the employment setting, but it has to be consistent with the First Amendment. And we've got, really sophisticated rules to show how that's supposed to work out in court. We call it the Pickering balancing test. So at our arguments yesterday, we had plenty to say about that. So it's a sophisticated issue. There's not a simple yes or no. But in Ms. Brown's case, it comes about as close to an absolute yes First Amendment rules as you're going to see in these cases. Again, because there's no disruption, no evidence of disruption shown by the agency, her post was not offensive or calling for violence. And again, no disharmony in her office. Her relationship with her peers is unaffected by what amounts to a private political statement.
As I understand it, from what you said to reporters outside the courthouse yesterday, you've been contacted by other government employees as well who've been fired for posting negative comments in the aftermath of the death of Charlie Kirk.
Yeah, I've had serious discussions with about half dozen. I assume some of those will eventually turn into litigation themselves. But dozens and dozens of people were terminated or being investigated or were suspended. I've talked to a college professor. I talked to a public school educator. It's been a pretty widespread thing in our state. And there's at least one reported case from out in South Dakota where an art professor was suspended from his teaching. So it's not an isolated thing. It's across the country. But the magnitude of it, the sheer number of people seems to be unique to Florida.
Yeah, we have seen quite a crackdown and a big focus on that here. Does that reaction or response surprise you?
Very much so. Very much so. So in part because it's what we call viewpoint-based discrimination. So the state's not letting people go who are, said favorable things about Mr. Kirk. And whatever you think about Mr. Kirk or his politics, he was a very divisive figure in our country. Not everyone was on board with his political and religious message. We've got to be able to debate that sort of thing openly. And when we see firings because of political posts, we saw a number of them, for instance, in the middle of the George Floyd Black Lives Matter cultural movement. They tend to be very isolated. You just don't see the mass firings, suspensions, and investigations you do in regard to Charlie Kirk. There's something about his assassination that has really struck a nerve, I think, with the conservative members of our society, and particularly, I think, with the DeSantis administration.
So what's next with this lawsuit as we wait on a ruling on that injunction?
Plenty to do and in short time, actually. So injunctions are extraordinary remedies. They're hardly ever granted. And particularly when we're dealing with employment and our request to reinstate Ms. Brown to her job, that's just not usually granted at the front end of a case. Perhaps we'll be successful, perhaps not. But Judge Walker has put us on an extremely accelerated schedule in terms of finishing our depositions, doing our paperwork for summary judgment. So the case will conclude sometime early next year, regardless of how the injunction goes. So, we had a lot of good work to do on Monday, and we're going to be really busy over the holidays and into the new year to finish up the case.
All right, Gary Ettinger, First Amendment attorney, representing Brittany Brown in this case, this lawsuit against the FWC over her firing. We appreciate you joining us, giving us an update on what happened in court yesterday in Tallahassee, and I hope to talk to you again.
Thanks, Garrett. It was a pleasure.